My name is Peter Doman. I'm a solicitor in Matthews Folbigg's Workplace and Employment Law team. One of the most stressful aspects of running a business is disciplining and dismissing problematic employees. Whilst dismissal is undoubtedly distressing for the employee concerned, it can also be fraught with anxiety for an employer, both when preparing for the dismissal and following the dismissal when waiting down the clock for a claim. In order to protect against dismissal claims, it is vitally important that employers know what type of claims are available to employees and the various differences between them. In this video, I'll be focusing on the main two types of dismissal claims available to employees under the Fair Work Act. These are unfair dismissal claims and general protections claims. An unfair dismissal claim is a claim where an employee alleges their dismissal was harsh, unjust, or unreasonable. To avoid such a claim, employers must ensure that the reason for the dismissal is valid and genuine, and that the decision to dismiss the employee is not disproportionate to the work performance or conduct issue. Employers must also ensure that the employee is afforded appropriate procedural fairness. For example, the employee must be given advance notice of relevant performance or conduct allegations and be informed that the issues may result in their dismissal. The employee must be given an opportunity to respond to the allegations, for example at a meeting. The employee must be permitted to attend any meeting with a support person if this is requested. And the employer must ensure that any disciplinary action taken against the employee complies with any relevant policy or procedure. Most importantly, an employer must ensure that any decision to dismiss an employee is not predetermined. The appropriate amount of procedural fairness required to be afforded to an employee can often depend on the circumstances, including the employee's age, length of service, seniority, and their prospects of future employment following dismissal. Finally, it is important to note that some employees are ineligible to bring unfair dismissal claims. These include employees dismissed during the minimum employment period, certain high-income earners, or employees whose positions are abolished due to genuine redundancy. In contrast to unfair dismissal claims, general protections claims are claims where a person alleges they were subject to adverse action, such as dismissal, for one or more prohibited reasons. These prohibited reasons include because the person has exercised a workplace right, such as making a work health and safety complaint, or making a complaint or inquiry about their employment, because the person engaged in industrial activity, because of the person's age, race, gender, marital status, or other discriminatory factor, or because the person is temporarily absent due to illness or injury. Unlike unfair dismissal claims, general protections claims involve reverse evidentiary onus. This means the employer must satisfy a court that the reason for the dismissal or adverse action was not infected by the prohibited reason. To protect against general protections claims, employers must consider whether there are any circumstances or conditions that may allow an employee to claim their dismissal was based on a prohibited reason. For example, whether the employee had recently made any complaints about their working conditions, whether the employee had recently used or returned from leave, or whether the employee has any medical issue that may be contributing to any genuine performance or conduct issues. If so, the employee must ensure that the dismissal is not infected by these circumstances, and preferably keep documentary evidence that illustrates the decision was based solely on genuine performance or behavioural issues. Finally, it is important to note that limited defences are available to several of the prohibited reasons. For example, an employer is permitted to dismiss an employee due to the employee's disability, illness or injury, but only if the employee is no longer fit to perform the inherent requirements of their role. In sum, we strongly recommend that employers obtain professional legal advice before dismissing an employee so that the risks of any claim may be identified and minimised. Thank you.